All right. Could I impose on you just to run the slides?
Sure.
That won't take too much of your strength.
You bet.
Thanks. Sorry, that would be out of my technological abilities.
Absolutely. Welcome, everybody. As Ian just mentioned, I'm a little under the weather, so I'm going to probably have Ian run most of this, but I'm here as well, and I'll run the slides and help if I can. So the agenda is here.
Awesome. Okay, Jordy, for sure. Take it at your pace. All right. So here's our agenda in terms of what we're going to try to get accomplished today and cover. What are guardians of property and when can guardians be appointed? The roles and powers and duties of guardians, and then guardianship applications generally. And on the last one, I will give a shameless plug for our second edition of Power of Attorney Litigation by Susanna Popovic-Montag and myself, which we came out with recently, and are pretty happy with it because it's not as thick as probate practice, and it covers a lot of these contentious parts of what can be and the non-contentious aspect of our practice. So guardians of property generally, and as Jordy's slide so properly identifies, the court appointed representative of a mentally incapable person is necessary when someone does not have a power of attorney for property, there's a dispute, there's no one named or who is willing to act, or there's that's a foreign guardianship order. So just breaking those down, the great Arthur Fish, who is now retired and no doubt enjoying his time away from the practice, always used to say that getting a power of attorney was one of the cheapest forms of insurance that we have. And it's so true, because those who do not have a power of attorney for property when it's needed horribly regret it, because the guardianship applications themselves are cumbersome and expensive, and there are some barriers to entry that just don't exist, of course, when you do a proper power of attorney. So when your clients say to you, geez, you know what, I don't know if I need to bother doing powers of attorney as well as the wills, using eState Planner and using other software and that has it pre-populated, you can pull these things together fairly efficiently. And if you haven't, your precedents for powers of attorney are pretty easy to get to, and it is a huge value add for the client. And much more importantly, it's a value add that you can be properly describing to your client the obligations and roles and duties that are going to exist with that job if you do it at the time. So when there's a dispute over the validity of a power of attorney, that's why I had my shameless promotion of Power of Attorney Litigation, second edition. That is, unfortunately, I think, I will say, but probably the largest growing area in the practice of a capacity litigation in Canada. Almost universally when I talk to my colleagues, that this is the disputes over the validity of a power of attorney or the appointment or the removal or some form of the litigation that surrounds powers of attorney is growing faster than even will challenges and other areas that were sort of conventionally seen as the bread and butter for capacity litigation. And I say it's unfortunate because it really is a bit of a family fight over, quite frankly, the body that's not gone. Then, of course, the circumstances where there's no named attorneys, and that's again a great drafting tool and a great value add that we can give to our clients to when they do powers of attorney, and when lawyers are doing it, we can canvass with them the choice of attorney to make sure that they're going to be willing and able to act, and B, alternatives, putting more than just one choice there, given the possibility that the first named person can't or the group of people can't. It's an important discussion to have with the clients, and I try not to leave a meeting when I'm doing a power of attorney without putting an alternate in. It's just, as I say, so much of a headache if we don't have our named powers of attorney who are willing, able to act. You pop back up into the litigation realm or potential litigation realm. And then, of course, there's a foreign guardianship order. And Jordy, I'm happy to impose on you on your thoughts on this, but it does happen from time to time where we will get a foreign guardianship order, or even a power of attorney from a foreign jurisdiction. And you've called up Section 86 of the Substitute Decisions Act, which speaks to this precisely.
Yeah, it can be.
Go ahead.
You can often get in a situation where you need to do a separate guardianship here in Ontario, depending on the jurisdiction and the circumstances. So you could actually have two separate guardianships going on at the same time.
So that's another headache. And I guess, before we move into the sort of steps to get the order, my last comment is, although we can preach all we want about getting powers of attorney for property organized before, if there isn't one, or if you fall into one of these four categories, then we need to look to, in Ontario, the Substitute Decisions Act, and craft the necessary materials to get a court-ordered appointment for guardianship. And that process requires what I've said earlier, some real barriers to entry. And the first is we look at is the criteria for the guardianship order is that the starting point is that sorry, Jordy, the first is that a person must be incapable of managing property. And now that the slide goes on to describe what that means. That the important thing here, of course, is looking to Section 6 of the Substitute Decisions Act, which, of course, Jordy is called up here. The difficulty here is this: with a guardianship order, unlike a power of attorney, a continuing power of attorney, which can operate from the moment of its execution, a guardianship order cannot be made unless there's a finding of incapacity. And that can be something that can be real cumbersome. Getting the ability to have a proper assessment before the court, or B, just simply getting that organized from a logistics standpoint, depending on the person's capacity. So that, when I say barrier to entry, that is a foundational decision that the court has to make. So you're not going to get your order without the finding of incapacity. And so I always want to think ahead and think, geez, what evidence can I find to make sure I hit that that foundational threshold to even getting a guardianship order. So, sometimes you have situations where someone is comatose. That's obviously a little easier to get a letter from a doctor to say that. But when we get into the areas of gray area of capacity and so forth, and there's competing levels of analysis on that, it can be a real difficult issue. And quite frankly, you're going to have to satisfy the court that there is an incapable person in the context of Section 6. All right, so the prohibition on, sorry, go ahead, Jordy.
Yeah, maybe just address the idea, which is kind of unique, is not only must there be a finding that the person's incapable, but by reason of the incapacity, it's necessary that you have to appoint someone to do it. So it's a last resort, and it's only, you could be incapable and it's not necessary to have decisions made on by someone else, because there are no decisions to be made, or there's some other, and we'll see the legislation about how it's, the prohibition. But this is a key element that just because the person's incapable, there's still another set of criteria that's required for a guardianship order to be made.
Yeah, and you find with judges when they're making these decisions, the first thing is they're looking for capacity evidence, and the second is, do I need to be here? Do I need to do this? No judge wants to make a finding of incapacity. It's a heavy hammer to drop, and so from my standpoint, anyway, I find the judges really do look into this less restrictive options, or does this require? Do the circumstances really require this the court to intercede with this and make such an order? Because the guardianship order, of course, is in a finding of incapacities is a bit of a no looking back situation for the courts, and they want to be very careful before they do it.
And the courts, especially if you are in, and you could speak to this maybe, Ian, about the idea that you got to show that there isn't some other alternate course of action that would work just as well. Or because the court can say, yeah, the person's incapable, but I'm not there. We got another way of managing this person's affairs, and that I don't need to make this order. Do you want us maybe speak to that a bit?
Yeah, I mean, I kind of find it a bit policy wonk sort of language in a way, because it is very difficult to find that alternative when you have most of your cases. The least you always want to look for the least restrictive, but the alternative course of actions are difficult. But I have seen it where situations where everything's set up in automatic withdrawal, the situation isn't urgent, and there's a chance of recovery, all those sorts of elements of it. The courts will obviously look to, or they'll make a finding that it's a temporary appointment, which is, again, I'm not sure they are doing it, but I'm not sure that's, well, it is good law because it's happening, but I'm not sure that was the intention of legislation initially, but it has expanded to that. So there's all sorts of flexibility there. The bottom line is, if there is a creative solution, the courts will embrace it if it's going to make sure that the potentially incapable person is well protected.
Sorry about that, Ian.
Oh, it's fine.
There we go. So there's some rules about who can be appointed.
Yeah. So, I mean, it's broad, obviously. We have a free and democratic society, and we're typically allowed to make our choices for guardians. But the limitation, of course, comes down to healthcare, compensated healthcare, or residential social training or support services individuals. The PGT will not take the job unless they consent, but they will consent from time to time, and they are the right choice from time to time. So it shouldn't be looked at as a hurdle that is impossible. Often the PGT will, in the right circumstances, consent, and non-residents, of course, can't be without posting or dispensing with the security, which we can talk about a bit later if we have time. But obviously it's much the same as an application for a state trustee and so forth, where you have situations where people are non-resident. The courts want to be extra special protective, but those are sort of the who can and who can't be. The criteria, of course, for selection of guardian is whether the proposed guardian is the attorney. Well, the criteria for the selection is whether or not the proposed guardian is an attorney under continuing power of attorney, or the incapable current person's wishes, if they can be ascertained or somehow identifiable, and that person who's being chosen makes sense from ascertained wishes, and then the closeness of the relationship. And that's where, of course, the litigators get frothy and excited, because the closeness of the relationship of the applicant to the incapable person is always in the mind of the applicant. And everybody can tell a good story about how they should be the better person, and the one who should be looking after the incapable. And that, obviously, see that when you have siblings fighting over the job, which can be, as I say, horribly contentious and difficult to manage from a court standpoint, but also from an economic standpoint. These fights tend to be outrageously expensive, and we'll hear more about costs, no doubt, but costs are by no means a guarantee. In fact, it is typically approached that if you're going to get into one of these guardianship fights and you think you're the better person or the other person is the wrong person, you better be prepared to pay the costs, because the courts are fairly strict about pay or play approach to costs.
And the idea about appointing more than one person is, do you see that very often, or when would a court sort of consider that?
Well, we do that a lot in situations where there's an accident, a situation that the personal injury bar will come to us and say, look, we need to get a guardian appointed. This person suffered a severe accident. We want the mother to be a guardian because she's on the ground dealing with everything day in and day out. But we have a lot of money here, so we don't think we'll ever get over the bonding requirements and so on. So let's also have that with a trust company. So you can see that situation unfold, or multiple parents. The joint appointments are fairly regular when you have significant assets that you're managing. When it's more modest, the court might be more flexible. But and it also situations where you have a divorce situation or something like that. There might be those personal circumstances, but generally speaking, the joint appointments are embraced by the court. It gives a nice comfort to the court to have a check and balance, whether it's a trust company and an individual or a couple of individuals. The courts are always looking for these judges want to sleep at night, and they want to say, geez, you know what, I did the right thing here. It was a tough circumstance, and they're always tough circumstances. These facts are always horribly difficult, always, most of the time, are horribly difficult to suffer through in terms of the judges, and they want to know that they've done the right thing from a protection standpoint, and that's where the multiple appointments can come in really in handy.
Do you ever
Go ahead.
do you ever see, because there is a provision that you can have a guardian with respect to just certain pieces of property. Do you ever see that? I mean, maybe with foreign assets, or have you ever used that? It's
rare, but it's good flexibility that's in the legislation. For sure, with foreign assets, it's a great tool, and I've used it a couple of times with unique assets. One, for example, was a literary situation where the individual had a book collection that was specific and needed to be managed because they were in the process of selling it, and the individual got into a car accident, and they needed someone to step in to finish the process. And they appointed someone just in respect of the literary works. So you can see that as being again, the courts want flexibility, and that's another great flexibility point. I just put this in, and I don't know if you want to talk too much about it, but often we hear we might hear rumblings from our clients that says, my mom's incapable and there's, something going on there. And maybe just the involvement of the PGT as an investigative. Yeah. So like CRA, this is a rat line. You can rat someone out, you can complain, you can get to the really to the source of an urgent investigation. There are, I know from the PGT's office, they take it very seriously. They're understaffed and overworked in many respects, but this is one area where you see some pretty careful attention. I know it used to be that in the old days, that there was a group that had to carry pagers around for 24 hours. Now they get probably government issued cell phones, but it's an investigation that can be undertaken on an urgent basis, or of course, one that you can alert the PGT in a regular application. They typically are only interested in getting involved, if at all, in an investigation on an urgent basis. But I have seen situations where in the course of the application, the materials sought, they asked the court to order the PGT to make an investigation where there was some threat of elder abuse. There wasn't actual evidence of elder abuse, but there was some threat. So they asked the PGT to do some investigating. PGT did not want the job in that situation, but that was because of different facts. But yes, that's and you can see from your slide the threshold for them to engage is very high. They just don't have people on standby jumping in their Chevettes chasing down these problems. They are overwhelmed with their workload, and so they will react typically, I find, but only if you've really hit the ball. You got to ring the bell on all of those factors. So maybe we can just turn into the procedure for guardianship applications and some unique things about who you have to serve and things like that. But this is obviously the consent of the guardian, but maybe you can speak to the evidence of incapacity. You mentioned that
but there's no requirement that there be a formal assessment, but there has to be evidence of incapacity. Maybe take us through sort of what kind of evidence there you typically see, which is, assessments.
Yeah, you'll often look for the assessment itself from a qualified assessor. You can typically get, if you need to, as I say, in circumstances, you can get a doctor's note or a report. But never underestimate the level of evidence you're going to need there, because the court will not simply rubber stamp, in my experience anyway, rubber stamp a finding of incapacity. And they're not silly about it, of course, if it's an obvious one, but I can tell you that there have been many a time where people are sent back to get better materials to give the judge more comfort that the capacity is indeed there, incapacity is indeed there. And so those are obvious important elements of it. So just in terms of process, it's a notice of application under Rule 14, and you put to the court the proposition of the appointment, and you put forward the core evidence you're going to need in respect of incapacity. You're also required in a court form is to include a management plan, and that management plan for property will typically set out in detail how and what things are going to be spent on and how you intend to move forward with the finances. And again, the nature and extent of that evidence should not be underestimated. When these come in, the Public Guardian Trustee's Office is always served. And sometimes you'll find that they're the ones who are critical of the management plan of having not enough detail. And obviously, if you get that kind of a response from their office, then a court is going to be hesitant. They're typically not going to go against the reasonable expectations and suggestions of the PGT. And so I find, again, this is where this process is cumbersome. It's many thousands of dollars. I mean, people can budget how they want and pricing it from a legal fee standpoint, but just look at what you have to do. You've got to issue a notice of application. You've got to get, you've got to serve it on the alleged incapable. You've got to find evidence of incapacity. You've got to put a comprehensive management plan together, and you've got to have all of those boxes ticked with a draft order. So this sort of application does not just come with an overnight, I don't know how easy it'd be on Chat CPT or whatever it is, but this is not easy material to put together, because it has to be so fact specific. So it's legal work. And, I always say, I bet you the cost of a power of attorney for property, whatever the pricing on that is, it's pretty modest compared to having to bring a guardianship application. Unfortunately, sometimes you just have to, but and that's situations where people have not gotten themselves organized, or they're in a catastrophic situation that they hadn't anticipated. I have a standing rule that anybody that will listen to me gets a power of attorney for property done when they turn 18. Kids wills and stuff aren't as big a priority with young people because their assets aren't typically much to worry about, but a power of attorney at age 18 to all my clients' kids is something I say is a very good idea, and this is an illustration as to why. Again, shameless promotion on going forward on this, but what we did in our second edition of power of attorney litigation is we talked about some of the strategic considerations for these applications, and we have a whole chapter on some of that as well. So just from that standpoint, important to keep in mind.
Can I just ask a question here?
Yeah, of course.
Often we're in a situation where, this person's incapable. We're a family member, but we have no access to any information about their assets or any of that. How do you deal with that? I mean, you're saying to the court, listen, I want to take on this job. I don't even know what the person has. Yeah,
we're all used car sales people at this point in life, and we've got to put our best foot forward. And if we've got a Volkswagen that isn't running well, or we've got a Porsche, we've got to work with it. And so if we don't have the necessary materials, the PGT will typically say that's fine, as long as you've undertaken to file a further and better management plan within 60 days of your appointment. But they're not going to just say that if you haven't tried. So you're right. If you haven't got the material, that's fine. So my first is always, have I really tried? And have I got a good reason why I don't have the materials or the information? And if I do, then the PGT will typically do that, and the courts will typically embrace that position. Remember, this early filter through the PGT's office is typically where you're going to find the biggest bumps in the road and where the court's going to be most reliant. And having seen hundreds of these letters over my career, these are definitely central themes. Good capacity evidence, as much as you can tell me on the management plan side and promise to tell me more. And typically we'll also say that, from my standpoint anyway, I'll often put in a management plan, or even in the order, that we'll update the management plan on an annual basis if it gives the PGT some more comfort. And they're usually pretty good about dialoguing about that.
Can you just quickly, this is unusual because normally in litigation, you only have to serve the parties. What's unique in a guardianship application is our obligation to serve people who aren't parties. And do you want to just briefly speak about the family service requirements?
Yeah, well, I mean, it's important to take a look at section 69. It's not always carefully followed, quite frankly, but it's important to manage it because there is an expanded group. Now, this is the same as with dependent relief. Like, you've got, typically we used to run those files as well with limited service just on the estate trustee. Well, now we're saying, okay, as a decision of Justice Nordheimer that said, no, expand it to the beneficiaries under the will as well. And this is the same situation. They're saying, look, get it obviously to the PGT, obviously to the person who alleged incapable and their family. And they identify who in the family under section 69. So that expanded service is so important, because if you don't do it right, again, you're going to be sent back, and it's only going to cost more time and money for your client.
And the last thing is, just in the last few minutes that we have, maybe address what you typically see in a order for guardianship.
For sure. So just 10 seconds on the other point, though, is the summary procedures available in the legislation. And unless things change, it still is not a good idea. It's typically the courts are reluctant to pick up on anything that's going to short circuit this in any meaningful way. So I just make that as a practice point. In terms of the form of the order, again, these are important considerations, because it comes back to flexibility. If the court's going to be flexible, you want to give if you want to give the court some flexibility, you want to give them a better feeling so they sleep at night thinking they did the right thing. Limited or unlimited time periods or options, conditions for security. We'll often almost always put in a period of time when we'll pass our accounts. We'll typically say we'll pass our accounts within 3 years of our appointment. It keeps a good cadence of disclosure to everyone going. And then, of course, as I talked about, management plans, amendments, and so on, and then variation or substitution. What are you getting at with that, Jordy?
Just that there is a procedure if the guardian can't do it anymore. How you substitute, there's a special procedure for substituting a guardian, because there's already, of course, been a finding of incapacity. And so but there's a procedure for varying a guardianship order and terminating it or substituting another person for that. People know that this isn't rehearsed. They know it's live when you ask, what are you getting at here, Jordy?
That's right.
What's amazing is that we pull this off.
Well, especially with you feeling so lousy. So thanks, Jordy, for pulling it off this week.
My pleasure. And I hope everybody had a great Canada Day weekend. And we're on summer cadence for our webinars. So every other week in the summer, and we avoid the long weekends. So we'll see you in a couple of weeks. We'll be back, and hope you're enjoying your time. And thanks again, Ian, and thanks to everyone who was here.
Thanks, Jordy. Take care.